everybody. I think it's right here at about 11:30, so I think we'll go ahead and get started. My name is Meghann Joyce, and we're going to be doing a presentation this morning or this afternoon here on FMLA. I'm going to start out kind of with some basic information about FMLA, what it does, what types of claims can be brought under the FMLA, and what some of the elements of those claims are, and then we'll walk through some other hypotheticals as well to kind of put a little bit more meat on the bones in terms of FMLA's requirements. So I think the first question, of course, is what is FMLA and what does it provide to employees? So the FMLA requires, as some of you may know, employers to provide up to a total of 12 weeks of unpaid leave. And that eligibility is for any employees that have been employed for at least 12 months by the organization. And so, as you can see there, that's why we have the 12. It's available during any 12-month period. It is allowed at certain times. Generally, we say that it's any serious health condition that is affecting that employee or a family member. And then the language of the law specifically also extends to the birth or adoption of a child. There are specific definitions within the law about what qualifies as a family member, and we'll talk a little bit about that later in the presentation. But it's generally for any serious health condition that affects either an employee or a defined family member. Generally, the FMLA leave is unpaid. It doesn't guarantee that employers provide paid leave during that 12 weeks of leave, but paid leave can be substituted during that period of time. It doesn't require employees to use their paid vacation time, although, as we'll talk here a little bit, it's important for employers to have a policy that governs when an employee can use paid leave on top of or in substitution for some of the unpaid leave under the FMLA. So the FMLA is very nuanced, and it's an area that creates a lot of questions and problems for people and HR representatives, and we'll talk a little bit about some of those issues here as we go forward. But I think before we get there, it's important to understand how incredibly pervasive FMLA is. So FMLA was first enacted in the 90s during the Clinton administration. So it's been 26 years now that the FMLA has been in effect. When we look at some of the Department of Labor statistics, those statistics tell us that the FMLA has actually been used nearly 100 million times since its enactment. And there we have some of the statistics on the reasons. 21% are for birth or adoption, 55% for a personal medical condition, 18% is for the care of another or for the medical condition of one of those defined members, and then 2% for other reasons, which also includes military reasons. I thought that this statistic was really startling, that over 10% of the American workforce are on FMLA leave at any given time. And so, you know, when we look at the number of people that are members of the American workforce, there are literally millions of Americans that are using this benefit at any given time. And 91% of employers report that FMLA does not have a negative impact on absenteeism, turnover, morale, or productivity. And so I thought that was an interesting statistic as well. So despite its use and despite the fact that it's been around for more than a quarter of a century, the FMLA still seems as though it creates a number of problems for employers and HR representatives. It seems that mistakes are incredibly common, and they can run a gamut of issues from, not providing employees the notice that is required, and not counting leave appropriately or not allowing leave under given circumstances. The total number of complaints is decreasing, although we are seeing that the number of complaints that are actually resulting in violations is increasing. So in 2018, of all of the complaints that were made, only 53% resulted in violations, as compared to in 2011 when 42% resulted in violations. And of course, those violations are important because the average cost of defending an FMLA lawsuit is currently estimated to be about $78,000. And of course, that doesn't include the fines and additional risk exposure if there is violation or liability found in a civil lawsuit. So, we talked a little bit about the leave that is actually guaranteed or protected by the FMLA. But the other aspect of FMLA that's important to understand is that it does require that the employer reinstate the employee to a virtually identical position. And when we're talking about, what is a virtually identical position, that means that the employee needs to be restored to their former position in terms of pay, benefits, working conditions, privileges, prerequisites, and status of that position, and that the position that they're restored to must also involve the same or substantially similar duties and responsibilities as their prior position before they left for leave. And I included a note there to specifically note that a reduction in hours to half-time or a change in hours does not qualify as an equivalent position, because that's something that we do see quite a bit. Also, there are very specific requirements that are set forth in the FMLA in terms of what happens if an employee is going to be laid off during FMLA leave. So in those circumstances, the employer actually has the burden of proof to show that the employee would not have otherwise been employed at the time that the reinstatement is requested. And so, that's an interesting change in this particular law, is to actually place that burden on the employer rather than the employee. So in other words, they have to show that the employee would not have been, that the employee would have been laid off during that period and would not have been entitled to restoration had they not taken the leave. I think that the important takeaway there is that as a general matter, courts don't look very favorably upon job elimination during FMLA leave, and so to the extent that it's possible, job eliminations or layoffs of employees while they're on FMLA leave are highly discouraged. If it absolutely has to be done, it's really important that employers be very diligent in documenting the reasons for that layoff and the timing of that layoff as it relates to that particular worker, so that if it does become an issue, they have the evidence and the documentation that they need to be able to satisfy that burden of proof. So there's really fundamentally two different types of claims that you might see brought under the FMLA. The first one is an interference claim, and this claim arises out of the prohibition in the FMLA on an employer's interference with an exercise of FMLA rights. So an interference can include a number of different things, not only refusing to authorize FMLA leave, but also simply discouraging an employee from using such leave through comments or, creating a hostile environment for that particular employee. And any employer that discourages an employee or tries to interfere with an employee's ability to exercise FMLA rights may be liable. So with an interference claim, the employee only needs to show that she was entitled to the denied benefit, um, and that the employer engaged in some sort of conduct. She doesn't necessarily need to show that the employer intended to interfere or that the employer intended to discourage her from taking the leave, merely that it had that effect. Really, in these types of claims, what we're looking for is there some sort of conduct that's going on here in the workplace that is going to discourage or chill not only this employee's desire to take FMLA leave, but is it going to have an effect on other employees in the workplace too? Are they going to fear that they might be experience some sort of retaliation or reprisal for taking that FMLA leave, which then brings us to the other type of claim. So in addition to prohibiting interference with an employee's exercise of their FMLA rights, the FMLA also prohibits any type of discrimination or retaliation against an employee for asserting her FMLA rights. So if you're familiar with some of the other federal civil rights jurisdiction laws as it relates to employment, we often see that there's this burden shifting framework that is applied in any kind of discrimination, harassment, or retaliation case, and FMLA really isn't any different. So FMLA, like those other types of claims, are subject to this burden shifting framework. So the first thing is that in order to go forward with her claim, an employee must establish that there is some prima facie case of retaliation for exercising FMLA rights. And as it relates to these types of claims, there are three prongs to that prima facie case. First, the employee must establish that she exercised rights that were afforded by the FMLA. Second, she must establish that she suffered some sort of an adverse employment action, and that can be, any change or in the terms of and conditions of her employment, not simply termination, but it can include, discipline, denial of benefits, things of that nature. And then finally, three, in order to make that prima facie showing, the employee has to show that there was some sort of a causal connection between her exercise of her rights and that adverse employment action. So if the employee is able to show those three things, then at that point the burden shifts to the employer. And at that point then the employer has to articulate a legitimate, non-retaliatory reason for its actions. So it's a kind of a presumption that arises. In other words, once that prima facie case is established, and then once that presumption is established, then the employer has to negate that presumption by showing this legitimate non-retaliatory reason. Then finally, if the employer can make that showing and can negate that presumption, then the burden shifts back then to the employee to ultimately demonstrate that the employer's proffered reason for the action that they took is pretextual. In other words, the employee has to show that whatever reason it was that the employer gave wasn't the real reason or the true reason for its actions. It's merely a pretext to cover up some sort of retaliation or discrimination against that employee for asserting FMLA rights. So as I mentioned, a clear policy is really important in navigating these FMLA issues. The FMLA is difficult, even for people who are very experienced in it, especially when we run into questions about how leave should be counted, and when we start dealing with paid versus unpaid leave. So the most important thing really is that policy be clear and that it be put in as simple language as possible to make sure that those things are clearly explained and that they're very easy for the employees as lay people to understand. And there I listed some of the issues that that policy should specifically address. It should include a clear explanation of exactly when leave can be taken, the procedure for how they request it, what forms they need to fill out, who they should contact, and we'll talk a little bit about that in a bit here in terms of there's often a lot of confusion about who an employee actually needs to have that conversation with within the organization. How is leave determined? Again, setting forth that policy in terms of what's the interaction between the unpaid leave that you're entitled to under the FMLA, any other paid leave that you might have, and then when will the FMLA leave expire? Again, as it relates to what paid leave you might be entitled to, and then what happens when it does expire. There's also notice requirements that apply to FMLA leave, and so the policy should also address some of those requirements specifically, and we'll talk a little bit about what those notice requirements are here in a little bit. Specify what the medical certification requirements are. So, as I mentioned, FMLA leave is available to employees if they have a serious medical condition or if there's a birth or adoption of the child. And so, to establish that it is a serious medical condition, there are medical certification requirements to establish that this is actually a condition to which the FMLA applies. And so any policy should explain what those certification requirements are as well. And then we talked a little bit already. Just make sure that the policy explains, how any kind of paid leave like vacation is used or can be used concurrently with FMLA leave. Makes it a lot easier if you can address those things head on and try to anticipate those situations rather than kind of doing it on an ad hoc basis. If you try to do it on an ad hoc basis, you're eventually going to run into a situation where people are treated differently, and then that's where a lot of times some of those retaliation and interference claims arise, is somebody complains that another employee was treated differently. So we're going to go through just a bunch of hypotheticals here, and I think some of these will help flesh out in a little bit more detail some of those things that we talked about in terms of medical certification requirements, who are family members, what are the notice requirements, and some of those things. So you'll notice kind of a theme here as we go through some of these hypotheticals. So we'll start with the first one. Daryl requests a week of leave for recovery after knee surgery. He's been a bit of a problem employee previously, particularly with attendance. His supervisor believes that he's just trying to get out of work. The supervisor suggests putting Daryl on light duty work during the week instead of allowing Daryl to take the leave. So, what to do in this particular situation? How should the HR individual handle it, or any attorney that they might be consulting with on this issue? How should this issue be handled? This is a pretty common mistake that you see, which is that employers have a tendency to want to try to treat what should be FMLA leave as late duty, or to offer that to employees in an attempt to get that employee back to work and get them productive as quickly as possible. So bottom line, this is an option that an employer can offer an employee, but it's not something that an employer can mandate an employee to do. If an employee asks for FMLA leave and it qualifies and they've provided the required medical certifications, the employer can have this conversation, but it's not something that they can require of the employee. I think that the best advice here is it's likely not wise to make this offer. I think there's a risk that an employee, if they're asked if they can do light duty, will try to do it, even though that may not be the best thing. It may merely be an offer, but the employee may not feel that they have much of a choice. And so ultimately it's not good for the employee or the employer to have an employee there on the job who really isn't in a position physically where they can fully complete their job duties. It can just run into some problems, I think. So the next hypothetical, on Thursday you notice through Jim's time cards that he's been out all week. When you approach the supervisor, Michael, he tells you that Jim has been taking care of his daughter who has chickenpox. You suggest that Jim should be on FMLA leave. Michael says that he hates you and that it's not a big deal. So what should we do here? This is really another common mistake that we see is where the employer or the employee is out for a period of time. The employee has communicated with their supervisor about why it is that they're out, and no one has communicated that to HR. And then the supervisor, perhaps doesn't have the training or hasn't connected the dots to realize that the reason that this employee is out on leave is for an FMLA qualifying reason. And then, at that point it's too late, and some of the notice requirements and other forms that needed to have been filled out for the FMLA leave have not been done. So as I said, common mistake, no one's talking to HR, and managers aren't communicating with HR to let them know that the employee is on FMLA leave, or perhaps the manager doesn't really even realize that what actually does qualify for FMLA leave. So it's just really, when we're talking about that policy that's included in an employment handbook in terms of FMLA leave, it's just really important that that policy requires that HR be involved in that process, either at the point that a manager becomes aware that an employee is out for a reason that probably qualifies for an FMLA, or whether that requires that that employee directly communicate with HR. Of course, that requires some sort of training, even further back than that, to make sure that the managers and the employees have a good understanding of what actually does qualify for FMLA leave. It's a good idea in that policy to just make clear that there can be any leave without HR approval. Ensure that managers know the processes, again, know what FMLA leave is. So another hypothetical, Andy is on a PIP for attendance. He requests intermittent leave for anxiety and anger management. Andy continues to have absences, some for FMLA reasons, some for other reasons. On a day where Andy is on FMLA leave, the supervisor writes to HR, "I want to terminate Andy today. These absences are putting a strain on our productivity." Coworkers are also making snide comments to and about Andy and his convenient no-shows. Andy's non-FMLA absences exceed the company's definition of excessive absences under its policies. So what do we do here? Again, another common mistake, managers don't know what they're doing, and they don't know the risks of some of that behavior. So managers, as we can kind of see here, often will retaliate against workers for taking leave. They'll dissuade workers from taking leave, or they might be asking for confidential information about the reason that an employee is on leave. Again, it's important that managers are included on all the training about FMLA leave, so they not only know what qualifies for FMLA leave and how it should be handled, but that they also know what the risks are in terms of not handling these appropriately or interfering or retaliating against employees that might require FMLA leave. So to just go back to this one a little bit too, if we go back to the facts here. Andy here is already on a PIP for attendance. If this is truly a situation where there have been good records that have been kept and it's clear that Andy's non-FMLA absences are exceeding what is an allowable absence, and he's therefore in violation of the terms of that PIP, it would be acceptable to let Andy go at that point in time. Of course, that's not going to be without risk. When you've got an employee that's kind of got some of these ongoing issues and they're using FMLA leave, there's of course a risk to letting that employee know. The employer might decide that it's worth the risk to let him go, but that's something that they would need to be educated about. The other complication here in terms of the risk is some of these facts here about the comments that in particular the supervisor has said about Andy and his leave, and they're put in writing too. And there's a comment here about absences putting a strain on productivity, but it's not entirely clear from that statement whether that supervisor is frustrated and upset with Andy's non-FMLA absences, or whether he's also expressing some frustration about the fact that Andy is on FMLA leave. So certainly in this situation, like I said, if it's clear that Andy is in violation of his PIP, if he's absent more than he can be or should be under the policies, he can be let go, but there's certainly going to be some risk there. Next hypothetical. It's your first day as HR director of a manufacturing company. You discover that the previous director, Toby, was a bit of a mess. You find out that there is an employee, Jim, who just came back to work after having a child. Despite letting the previous director know about his leave, the previous HR director never issued notices. Jim used some sick leave during this time, but most was unpaid. Jim is a star employee with a very good relationship with management. What do we do here? So, like I've mentioned earlier, this is one of the issues that we often see that results in violations, and that's not complying with some of the notice requirements under the FMLA. So it's really important that HR is aware of those notice requirements, and that employees are trained on those, and that that notice is posted constantly in the workplace so that employees can be aware of it as well. So generally, the FMLA requires that the eligibility notice must be provided within 5 days of the initial request for leave, including any possible reasons for ineligibility. So going back to this particular hypothetical, once Jim had made the initial request for his leave, the employer here should have provided that eligibility notice within 5 days. Along with that, a rights and responsibilities notice must also be provided within 5 days. And then a designation notice must be provided within 5 days of designated time off as leave. So once it's determined that the employee's leave is FMLA qualifying and it's designated as FMLA leave, then at that point, that employee is also entitled to notice of that as well. There's in addition to providing education, training of these, it's also important to establish some sort of a system to keep managers and HR professionals on task and to make sure that they're not missing their notices. So in this particular hypothetical, obviously a number of those notices had been missed. There are some loopholes in the FMLA that can allow an employer to go back and designate some of that time off as leave if that's appropriate, but it's certainly going to require some cooperation by that employee. And so that's kind of why that hypothetical had included some of that language about Jim being an excellent employee and having a good relationship with management. In this particular case, they could probably work that out, but certainly if it were a more difficult employee, these notice issues could become much more substantial. Particularly, if Jim has used this leave and now a few months down the road, perhaps Jim needs to have surgery, and we've got another FMLA qualifying event, and he wants to take more leave at the point that he's used this leave previously and we haven't properly noticed that and designated it. There could be an issue with that in the future too. Meredith makes a request for leave to care for her live-in boyfriend during his recovery after a rabies bite. Meredith has always been a great worker in a high-needs area, is in line for promotion. Around the same time, Angela makes a request for vacation. You know through social media that Angela's husband recently contracted shingles, but you are also aware that Angela is also pregnant. So what do we do here? So this kind of highlights something that I think that we often see in the Midwest, and that is that sometimes rather than not granting leave when it should be granted, I think sometimes we run into the opposite problem, which is that employers are being too generous in granting employees leave, particularly for non-qualifying circumstances like Meredith's circumstance there. Perhaps her domestic partner has a serious health condition, but he's not going to qualify as one of the family members under the FMLA. And so as serious as that condition might be, it's simply not, it's not a qualifying circumstance, and she can't take FMLA leave for that period of time. So turning then to Angela, we see there that so she has asked for leave for her husband, which does qualify if it's a serious health condition, and he is a family member, so that would qualify. But then we have the additional complication there that Angela is pregnant, and so she's trying to take vacation time to go care for her husband. And the reason that she's doing that is because she doesn't want this time off that she is taking to care for her husband to count towards her FMLA leave when she's pregnant. So the problem, we can certainly understand why she's doing that, but regardless, even if she wants to use vacation, that time is still time that she is taking to care for a family member with a serious health condition, and so it should be treated as FMLA leave. There is some case law from the West Coast, particularly from California, that kind of deals with that situation on FMLA leave and vacation. Some of those cases do state that in that particular situation you have to let Angela use the vacation time and not the FMLA leave. But most courts do follow the Department of Labor's guidance, which does state that FMLA leave must be taken if the employee is taking the leave for an FMLA qualifying reason, even if they would, rather simply take vacation time. Coming back to this bullet point, this really becomes a problem when we've got employees that are taking FMLA leave intermittently, kind of like the Andy situation. And so we've got non-FMLA and FMLA absences that are sprinkled throughout, and so it's not entirely clear whether that employee has actually exceeded their FMLA leave qualifying time, or if they've exceeded some of their other absence policies and things like that. I think particularly if it is an employee that's struggling with some sort of a serious health condition, like I said, we're generous, and so there's a tendency to just give that leave when it's not. But if there is some sort of a situation later on down the road where an employee truly needs that FMLA leave, it's not necessarily the case that you're doing them a favor by being more rather than less generous. An office employee, Kevin, who recently has been out for a foot surgery, submits a note from his doctor which states, Kevin is to be off work until he has healed. Kevin has a history of not being the most highly motivated employee. So this hypothetical kind of gets us into what is actually required for a medical certification. So when you do have an employee that's requesting leave for some sort of a health condition, it's really important to ask for clarification on that medical certification. What is the need for leave, and what is the amount of leave that's actually going to be required. And as the employer, those are things that you are entitled to that information to make sure that you're properly designating that leave as FMLA leave. Again, this often, like so many things, really becomes a problem when we've got intermittent leave situations. I'll also note here that under the FMLA, recertification can be done every 6 months, but more frequent certifications are permissible if the circumstances of the original certification have changed. So if there's some facts like an increase in the frequency of absences, or if there's any reason to doubt the validity of the absences, so sometimes we'll see that Friday, Monday absence pattern, or if the employee is asking for an extension of the leave beyond what was originally requested. Those are all situations in which an employer can ask for a more frequent certification than that every 6 months. Pam had a baby this year and took full FMLA leave. All salespeople have annual sales goals that they need to meet for bonuses and as part of their regular evaluations. Pam's goal was to sell 30,000 reams of paper on the year, and she sold 27,000. She's failed to meet her sales goals in the past, and her supervisor wants to terminate her for failing to make her goals. What to do? This is another common mistake, especially in sales types of situations like Pam, to make sure that there is an adjustment for those annual goals. So, again, FMLA requires that you restore the employee to their prior position in a virtually identical position, and that includes things like pay and benefits. So while that's true, there also still does need to be an adjustment for annual goals, like Pam in this situation. The FMLA doesn't require that bonuses be paid if those annual goals that were initially set aren't met, but the failure to reach those goals based on the fact that the employee was on FMLA leave can't be used against that employee. Creed has taken 20 weeks of leave after hip surgery to attempt to remedy some long-standing issues. Company policy allows 10 weeks of leave on top of FMLA leave. A few days before the expiration of his 20 weeks of leave, Creed sends HR an email requesting 2 additional weeks of leave to recover. Creed's supervisor has a very negative opinion of Creed due to Creed's suspected marijuana use and wants to terminate him for not returning. So basically, the employer here is going to allow, under their policy, 20 weeks. Allows 10 weeks on top of the FMLA leave, and a few days later he wants to extend that. What do we do here? So this hypothetical kind of raises the interaction between FMLA and the ADA. And sometimes we get so hung up in how do we count weeks, and especially in non-qualifying leave and qualifying leave, that the ADA, which is always lurking in the background of these situations, kind of gets lost. So first of all, to kind of point out some differences here. So the ADA applies to companies that has 15 or more employees, while the FMLA only applies to those with 50 or more employees within a 75-mile radius. So it's possible that, so we do have a lot of that overlap here. Now, while the FMLA has set limits on the amount of leave that can be taken, the ADA has a much less rigid requirement and simply says that reasonable leave has to be allowed as an accommodation, which is a necessarily indeterminate standard. So the question here always comes down to what is a reasonable accommodation for that employee, and so often employers, look at some of these set limits in the FMLA or in their policies, and they use those as sort of the guideline to determine whether the employee can or can't have the leave. But really, what needs to be done is that at the point that an employee is asking for some sort of an extension or some sort of an accommodation, there really needs to be an interactive process, and an employer needs to sit down with that employee and interact with them and get a good sense on what really is the need for leave, what's going on here, how much more leave is needed in order to determine whether that extension of leave is a reasonable accommodation. And if it is, then the ADA may very well require that extension be granted, even if it is above and beyond whatever the FMLA has limits for. It's also possible that it's not a reasonable accommodation. And if that's the case, then the employer has a decision to make about that employee. Kelly is out on FMLA leave to recover from throat surgery. While she is on leave, Ryan informs the supervisor that Kelly has been sleeping on the job and spending most of her time on social media. Jan wants to fire her. What do we do? It's very, very common, where we get calls from employers who want to quickly terminate an employee who is about to take FMLA leave, is on FMLA leave, or has recently returned from FMLA leave. Of course, just a good reminder of those interference and retaliation claims and the frequency of some of those violations that we're seeing. The reality is that if it's an employee who is about to take FMLA leave, there probably isn't a real good time to fire that employee. Same might be true of an employee who is currently off FMLA leave. It's likely not a heck of a lot better to terminate an employee who is about to an employee who has just come back from FMLA leave than it is to terminate one who's about to take that leave or is actually on leave at that time. So employers just need to understand the risks here, and they need to tread carefully. I think that if it's really a situation where the employee is not productive and they're perhaps a danger to themselves or they're a danger to other employees because of their poor performance, there's certainly situations where the employer might not have any choice. But if those are the situations, if the performance is really that poor, hopefully the employer has documented that over a period of time, and perhaps followed some progressive discipline to give that employee oral warnings, written warnings, suspensions, and that sort of thing, so that if the employee does complain, bring some sort of interference or retaliation claim, at least at that point, then the employer will have all of that documentation and evidence that they need to show that there was a legitimate non-discriminatory reason for taking that action, and that there wasn't some other true reason, some pretextual reason that employee was let go. So again, timing is really crucial. Whenever we're dealing with retaliation claims, courts, well, they say it's not everything, are always going to be looking for that sort of cause and effect relationship. So to the extent you can document and provide the employer that evidence to provide that legitimate non-discriminatory reason, that's going to be helpful. And if there isn't any of that documentation and there isn't that history of written warnings and oral warnings, now is going to be the time to do that and to start to put that record together so that eventually this employee can be let go. So that's all I have. If there's any questions, I'd be happy to take those. Otherwise, thanks for attending. Okay, hearing no questions. Thanks, everybody. Have a great afternoon.